So the issue of concealed carry bans is once again back in the hands of the Supreme Court, and we have a significant development which indicates what the Supreme Court is going to do new when it comes to concealed carry bans in states like New York, who are defying the Bruen decision. So let's talk about what just happened. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm is an amazing company. I love their supplements. I've been using them to get healthier. But one of the really cool things about 1st Phorm is they are pro Second Amendment, they are pro freedom, and they believe in what we do here on the channel. They support the freedom cause. Again, they're pro America. So if you want to get amazing supplements, I love their supplements, check out their protein powder. But also if you just want to support a company that's pro freedom, check them out using the links down below. And thank you again to 1st Phorm for sponsoring and supporting this content. As I mentioned in the intro, in this video, we're going to be discussing how the issue of concealed carry and various bans in the defiance of the Second Amendment and the Supreme Court's recent Bruen decision is now back in the hands of the Supreme Court. You may recall recently that 5 cases had been expedited and had hearings before the Second Circuit Court of Appeals because of recent warnings that the Supreme Court issued when it came to the Second Circuit's defiance of Bruen. Those 5 cases challenged New York's new Concealed Carry Improvement Act, also known as the CCIA. That New York law created a hyper-restrictive concealed carry law that was a direct response to what the Supreme Court said in Bruen. The state of New York passed that law just 8 days after the Supreme Court issued that 6-3 landmark decision. New York and the Second Circuit continue to defy that express decision, and now Gun Owners America has asked for the Supreme Court to re-review their anti-New York case and once again strike down the New York state defiance and strike down these concealed carry bans. And one of the very interesting things with this is this case, anti-New York, was set for conference. It technically kind of went to conference, but then out of that order, we got not a relist. We didn't get an order list saying that it was granted or denied. And then we also did not get a relist of the anti-New York case. Instead, the anti-New York case has been put on hold, which signals something very specific that is about to happen in this case. What is likely now happening is that the anti-New York case has been put on hold because the Supreme Court is set to decide the Rahimi case. We also recently got the Cargill bump stock decision, which was authored by Thomas, and that likely signals now that Alito is going to be writing the Rahimi decision, which is very good for us. I think Alito is going to write an amazing opinion. And what is probably going to happen now is the Rahimi decision is going to, of course, have the application of Bruen when it comes to the domestic violence restraining orders restrictions that is challenged directly in Rahimi. But with the anti-New York case now being put on hold, that means it is likely on hold for that decision in Rahimi, which means Rahimi is going to directly impact this concealed carry dispute, the application of Bruen, and probably a lot of other 2A cases as well. So with this case being on hold, the anti-New York case being on hold, that also means that once Rahimi is issued, we are likely going to see a grant, vacate, and remand of the anti-New York case. Now, if you're not familiar with what is going on in Bruen, the Supreme Court struck down New York's original May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. And one of the primary findings of Bruen was that the government bears a burden to prove that their restrictions or their regulations are based in the history and tradition of our nation, and those types of restrictions have to date back to 1791. Now, despite the Supreme Court issuing that 6-3 decision in Bruen, just 8 days after that decision, the state of New York passed the Concealed Carry Improvement Act, also known as the CCIA. And what the CCIA did is it created a scheme that was even worse than the one that existed prior to Bruen. This New York law, the CCIA, which again was passed in direct response to Bruen, was then challenged by multiple organizations in federal district courts, one of those being the anti-New York case, which was filed by the Gun Owners of America. Now, in the anti-New York case, the case originally sought emergency review from the Supreme Court because of what happened down below. Originally down below, the district court ruled in our favor, granted a preliminary injunction, but then it went to the Second Circuit, who then granted some blanket stays on that decision, just pretty much stopped what the lower court did as far as the preliminary injunction. Originally, on the first attempt, the anti-New York case went for an emergency review from the Supreme Court, but the Supreme Court denied it. But one of the good things out of that denial is we did get some language from Justice Alito saying that although they were not going to step in on an emergency basis at that time, what they were saying is that the Second Circuit had to correct this issue. Either they would have to issue an opinion with a rationale of why they granted that blanket stay, or they would need to expedite the hearings in these cases. And the Second Circuit decided to just simply expedite those hearings. Now, recently, the Second Circuit held hearings and issued their ruling on all 5 of those CCIA cases. Again, the big one was the Antonyuk case, because the Antonyuk case challenged the CCIA restrictions at large, the sensitive location provisions, the permit process, and all of that. Now, the Second Circuit ultimately vacated what the lower court said, so they vacated the preliminary injunction that was granted by the lower court. Now, in that decision, the Second Circuit tried to distinguish Bruen as an exceptional case. And as an exceptional case, the Second Circuit said that they could vacate what the lower court said here in the Antonyuk case because Bruen and Antonyuk are not one and the same. They said that Bruen was an exceptional case dealing with an exceptional issue, and they believed Antonyuk and the CCIA law, which was again passed in direct response to Bruen, was not exceptional. Now, in response to that Second Circuit ruling, GOA has now filed for a petition for Supreme Court review. Although this case is still at an interlocutory posture, the fact that this deals directly with Bruen, with that decision and New York's response to Bruen, strongly, makes this a strong candidate for Supreme Court review. Also, the fact that the Supreme Court has prior stated in this very case that there is a potential for reconsideration if the Second Circuit did not handle their business, if they did not appropriately review this, then the Supreme Court would step in. That also makes this a strong candidate for the Supreme Court to grant the petition. Now, of course, the outcome here of this Antonyuk case is very important for everybody. It's important not just because it would set Supreme Court precedent once again, because it would also impact New York, but it would also impact a lot of other states like California, who recently passed a similar law through SB 2. That's, California's new concealed carry restrictions. Right now, I'm part of the litigation as well in California. I'm one of the named plaintiffs in the CRPA lawsuit. Myself and Reno May joined as plaintiffs, and that's being challenged right now. And it's also being reviewed by the Ninth Circuit Court of Appeals, who's already signaled during some of the oral arguments that maybe they would just defer to what the Second Circuit said. So maybe they would just adopt already what the Second Circuit said in the Antonyuk case, find that SB 2 in California is also not exceptional. It's not an exceptional case, and therefore they don't have to apply Bruen. So that's already what the Ninth Circuit is signaling. So that's why the Supreme Court's review of this Antonyuk case is so important. Now, recently what happened in this Antonyuk case after that petition, the Antonyuk case was scheduled for Supreme Court conference a couple times. It went to conference, and then, we didn't get any news, no order list, and then it was rescheduled, and now I believe it's been rescheduled twice. The most recent reschedule in the most recent conference, I believe, happened on June 6th. So the following week, we were keeping an eye on the order list to see what happened. Now, one of the interesting things with the Antonyuk case is that conference for Antonyuk also involved all the Illinois rifle magazine ban cases. Now, that following week on the order list, we didn't see in these cases on a grant or denial, but then also we did not see a relisting of this case. And then soon, we pretty much got a signal that it would not be relisted for a new conference. Instead, Antonyuk appears to be on hold. Now, you may be asking yourself, what does that mean? What does that mean that Antonyuk now is on hold after it went to conference? Now that it's not being relisted, what does that mean? Essentially, what that signals is similar to what the Supreme Court did prior when they issued the Bruen decision. They put cases on hold, and they don't make really any firm decision on them until they issue a bigger decision. Really, what's probably happening here is that the Supreme Court is set to rule on the Rahimi case. The Rahimi case is going to come before the end of this Supreme Court term, before the end of June, early July, likely the end of this month. And that deals directly with the application of Bruen and the Second Amendment when it comes to the federal restrictions on people in possession of firearms and ammunition who are subject to domestic violence restraining orders. That is the Rahimi case, came out of the Fifth Circuit. The Fifth Circuit en banc panel said that using Bruen's application, using the Second Amendment, this type of federal restriction was unconstitutional. So the Supreme Court is set to rule in Rahimi, and with this hold of the Antonyuk case, that signals that the Supreme Court believes that the Rahimi decision is going to impact Antonyuk. After Rahimi, you're going to see probably a grant, vacate, and remand of the Antonyuk case back down to the Second Circuit for them to reconsider, reanalyze this issue in light of what they say in Rahimi. So this is all to say, in summary, right now, Antonyuk has been placed on hold. It has not been relisted for a new conference, and this is signaling that it is likely going to be held until the Supreme Court issues their Rahimi decision. And once they issue the Rahimi decision, which we're hoping now is going to be authored by Alito, it's going to be a favorable decision, and then can be used in these cases like Antonyuk and others, send them back down to the lower courts for a recorrection of what those second circuits and other circuits are saying and just misapplying Bruin. So if you get any more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.